All right, the jury has reported that they have reached a verdict. Ladies and gentlemen, when the jury announces the verdict, there are to be no protests, no outbursts, no disturbances of any kind. Whatever the jury's verdict is, we will respect the jury's verdict. State ready for the jury?
We are.
Ready?
Yes, sir.
Let's go in the jury. Ladies and gentlemen, the jury, did you choose a four-person?
We did.
Who is your four-person? Mr. Gilder?
That is correct.
Mr. Gilder, has the jury reached a verdict?
Yes, sir, we have.
Will you please stand? Mr. Gaul, please stand. Mr. Gilder, in count one, the first defined offense charging the defendant with first-degree murder, did the jury reach a verdict?
Yes, we did.
What is your verdict?
Guilty.
In count two, charging the defendant, the charged offense is especially aggravated stalking. Did the jury reach a verdict?
Yes, we did.
What is your verdict?
Not guilty.
And for the lesser included offense of aggravated stalking, did the jury reach a verdict?
We did.
What is your verdict?
Not guilty.
And for the lesser included offense of stalking, did the jury reach a verdict?
We did.
What is your verdict?
Guilty.
In count three, charging the defendant with theft, did the jury reach a verdict?
We did.
What is your verdict?
Guilty.
And with respect to the value of the property, did the jury find the property was worth more than $500 but less than $1,000?
We did.
Very well. And count four, charging the defendant with tampering with evidence, did the jury reach a verdict?
We did.
What is your verdict?
Guilty.
And count five, charging the defendant with reckless endangerment, did the jury reach a verdict?
We did.
What is your verdict?
Guilty.
And count six, charging the defendant with employing a firearm during a dangerous felony, did the jury reach a verdict?
We did.
What is your verdict?
Not guilty.
And as for the lesser included offense of possession of a firearm during a dangerous felony, did the jury reach a verdict?
We did.
What is your verdict?
Guilty.
And count seven, charging the defendant with the charged offense of felony murder, did the jury reach a verdict?
We did.
What is your verdict?
Guilty.
You can be seated. Mr. Gaul, you can be seated. Ladies and gentlemen of the jury, if the verdicts that have just been reported to the court are in fact the verdicts of you and each and every one of you, please indicate so by raising your right hands now. I count 12 raised hands. You can put your hands down. Is the state requesting any further polling of the jury?
Not from the state, Judge.
Is the defense requesting any further polling of the jury?
No, yeah.
Ladies and gentlemen, I thank you very much. You have worked as long and as hard as any jury I've seen. And this has been a really tough case. And you've indicated by the way you found you've been guilty of some things and not guilty of others, that you very thoughtfully considered this case step by step. I compliment your efforts. And I thank you. You can see that we cannot do this work without your help, people like you. So thank you very much. And at this time, I do accept your verdict. I will accept your verdict. And I do release you at this time. Thank you very much. You can be seated. All right, at this time, for counts 1 and 7, the court will have to go ahead and sentence the defendant. Those are effectively automatic sentences. Mr. Gaul, please stand. In count 1, the jury having found you guilty of first-degree murder, the court does not sentence you to life imprisonment with the possibility of parole. In count 2, the jury having found you guilty of felony murder, the court does merge that conviction into conviction count 1 And in those two counts, the total effective sentence is 1 sentence of life imprisonment with the possibility of parole. The court is obliged to revoke your bond and take you into custody at this time. We'll set a sentencing date for the other convictions.
Judge, we'll waive that 45 days.
Okay. How about
Victims would always prefer a Friday, Judge, I think, for their purposes, if we could.
say towards the end of June, June 29,
Judge, I won't be available 29.
22nd?
They won't be in town, Judge, that week.
We'll be closed first week of July. You want to go Friday, July 13th?
I won't be here then, Judge. Is there a possibility we can do that later in July?
20th?
20th. I'm available the 20th, Judge. It's good for us.
July 20 for further sentencing. Any other matters, Counsel? Oh, yeah. I will go ahead and make the announcement since this did create an issue once. The sentence has been today, so for those two counts, the 30-day time period for motion for new trial starts today.
And Judge, I don't think I heard the theft count or whether they fixed punishment, but the amount in that theft count, did they?
Over 500 less times.
Thank you.
All right, that completes we will be adjourned until 9 o'clock in the morning.
All rise, please. Word is adjourned.